The backbone of any employment relationship is the duty of good faith. You may have heard this thrown around, but how does this actually impact you? In this episode, I will give you practical tips on how to navigate the employment relationship and ensure that you never breach your good faith obligations. Hi everyone, welcome back to Lawlands. My name is Sanam and thank you so much for tuning in today. Look, when I started off in advisory many years ago, there were things that I learned that were word of mouth. And the reason why I say that is because it's quite common practice for HR professionals, employment relations advisors to learn things based off of their team leaders, their managers, and what they hear as a part of articles and information put out there, but they never get down to the fundamentals of the law, what's required either by case law or what's required in legislation. And it's because you are dealing with so many matters and so many cases, and a lot of times you may not study HR specifically at university and it might land you in that particular area. The reason why I say that is because everybody always looks at me and they go, oh, so you just must have loved employment law, right, Sanam? And I always say, no, I never studied it in university. I never really worked in it when I first started off in general practice. I may have seen one particular case, but other than that, nothing else. And it was only when I moved to New Zealand that I really got into the advisory space dealing with employment relations and saw how much we do day to day where we didn't really get down into the nitty-gritty of the law. And good faith is one of those areas. So I'll give you a story. When I was working in advisory, I, like many others, like I said, word of mouth, picked up this terminology, good faith. And I would say this is a breach of good faith or this undermines the trust and confidence. And so it wasn't until much later when a lawyer actually questioned me after I had written that something was a breach of good faith. And they said, why is that good faith? And then I was a bit dumbfounded and a bit stuck. And I just started rambling and I felt quite lost. So for anyone listening, I never ever want you to feel that way. More importantly, I want you to understand why lawyers say that you need to act in good faith or you have a duty of good faith to your employees or as an employee to your employer. For anyone listening, this is for you if you want to understand how to actually apply it within your business or apply it in your day-to-day when you are a HR professional. But before we get into it, you know what time it is. It's time for Laughs with Lawlands, where I give you a dry joke in these episodes. Yesterday, I couldn't figure out whether someone was waving at me or the person behind me. In other news, I lost my job as a lifeguard. I just thought it was really good. When I read this one, I was like, this is it. This is the one. Sometimes you can just be in complete denial, or sometimes you might miss the red flags or the signs. And good faith is kind of like that. It's a commonsensical part of the law. It's a common sense duty. Fundamentally, things that you would usually do in a harmonious relationship with people is what is required as part of good faith. So it's all about being productive in a relationship. Before we get into it, make sure you subscribe to Lawlands. Come over and connect with me on LinkedIn. Oh, and Lawlands is growing. I am planning on a weekly newsletter, so make sure you subscribe now to secure your spot for all of the Lawlands perks. Okay, when it comes to good faith, you may be thinking, what is good faith? Now, it's actually both on the employer and employee to act in good faith. So keep in mind, employers, it's not just on you. Now, Section 4 of the Employment Relations Act sets out and solidifies the requirement. Like I said, it's a common sense kind of requirement, but then you've got the actual legislation listing out 3 key elements of good faith. And I'll go through them and go through the wording that the Act uses, but we'll dissect it a little bit more in this episode. The first key element is that you should not, whether directly or indirectly, do anything to mislead each other or be deceptive with each other. And even if that conduct is likely to deceive or likely to mislead, then you should not be doing that at all. So the next element is that it requires both parties to an employment relationship to be active and constructive in establishing and maintaining a productive employment relationship. And what that means, among a lot of other things, is that both the employer and the employee need to be responsive and communicative. And then the third element is that an employee needs to understand the proposal or the proposed outcome or whatever the foundation is of a termination, of any redundancies. They are meant to give them an opportunity to comment, and they are also meant to lay out and have all of the information that the employee can access as to why they are coming to this proposed decision or why they are going to be making this decision. And this has to be done all beforehand. So 3 elements there. And you can see that if this good faith isn't a requirement, so let's say we have a lawless area of relationships between employers and employees, then each side will just be looking out for their own interest, right? Each side will just be working towards benefiting themselves rather than looking at the common good or looking at this as a constructive, working, productive relationship. And so that's the fundamentals of what is good faith. Now, I wanted to briefly touch on good faith in collective bargaining. I know many of you out there might not be in these unionized environments, but I thought I would just throw this in there very briefly, that there is a duty of good faith that also extends to collective bargaining and dealing with unions. And there are specific rules around this, and I will link the information so that you can go in and have a deeper read and a deeper understanding. But generally, it's because the employment relationship can actually include the relationship between a union and an employer, a union and a member of the union, and even so much as a union and a member of the union, where both unions are bargaining. So it can extend further out than an employer and an employee. And essentially the act itself, meaning the Employment Relations Act, will detail both parties needing to bargain in a reasonable way with the intention of actually trying to reach an agreement. So not coming there, like I said a bit earlier, around looking for the common good, making sure that you're working together and not just looking out for your own interests. But you may be sitting here going, okay, Sanam, that's all fine and well. Good faith, yes, I understand the legislation, but why do I actually need to know this? It's because good faith is wider than the legislation, and it's literally the backbone of the employment relationship. Broadly, good faith requires employees, employers, and unions to act honestly and openly. They shouldn't have any hidden motives. They need to raise things in a fair and timely manner. They need to work constructively and positively together. They need to be honest with each other. And they need to keep an open mind and listen to each other and be prepared to change opinions about a particular situation. All of these things, and I'll list out the links so that you can click on them and actually read through all of the broader good faith obligations, because there is quite a few. But all of these are essentially the foundation or the fundamentals to say that we are trying to work constructively and positively together. A lot of times, like in a disciplinary, if the employee is acting in a particular way that wasn't open and honest, and maybe they did steal from you, isn't that a breach of good faith? Not only is a breach of maybe their employment agreement, but also good faith obligations. And as an employer or an employee, these are really important because that means that both parties contribute to the situation. It's not just on the employer. Now, practical tips for employers is what I really wanted to focus on. And it's because I understand when you say good faith, as an employer, you must be thinking, okay, these are just standard things that happen. But time and time again, cases have proven us wrong. What we see is that a lot of times employers will breach that good faith because they haven't looked at the procedural aspect of a particular scenario they're dealing with. You may be thinking, how does this work within my business? And keep in mind, it's not just on the employer, it's on the employees too. So like I said, they also need to be honest and open, and they can't have any hidden motives. They need to raise things in a timely manner as well. And they need to be responsive to what you're sending them. If you're sending them a disciplinary invite, then they can't just shy away from that and just ignore it completely. They need to attend the meetings. A lot of times as a lawyer, when I would have people come in and I would assess their case to see whether we could take it on or what the merits of their case might be, it's really interesting to see the other side of it, where you've got the employer being really communicative, really responsive, and they're really trying to work with the employee. I saw one right before before I left private practice, and it was to do with a medical incapacity case. And the employee had come in, they called up in the morning and they said, look, I'm about to be terminated from my employment for medical incapacity. I want to see what I can do. And usually, in most cases, employers get a medical incapacity process wrong. But in this case, when the employee came in and met with me, I said, unfortunately, I don't see a successful case here because the employer at every turn sent letters to the employee that the employee completely ignored. And while they were off of work and they were returning back to work, they still weren't responding. So it was over months and months and months that the employer really tried to work with this employee, but they just clearly weren't responding and they weren't communicating. So it's really interesting because in those cases, definitely the employer does have standing. If an employer breaches good faith, that's where the employee can raise a personal grievance. It is heavier on the employer in the sense that an employee can raise a personal grievance for disadvantage, meaning that they were treated unfairly or they were treated like they shouldn't have been in the employment relationship. But in terms of the key things for an employer, it is so important to ensure that you do not mislead or be deceptive. Now, these are broader terms, but let's put it into practice. It's about making sure there's no hidden motives. For example, if you were doing a restructure proposal, it's really critical to provide all of the information up front. That's why we always say that your restructure proposal should have a genuine business reason. It should be quite detailed. It should really provide the reason why this is an absolute last resort because the business has looked at everything. And that is because it also ties into good faith obligations. So not only do we know that these are the requirements of a redundancy or a restructure process based off of cases, but this is a foundation. Keep in mind that this breach can be serious and it does have penalties as well. The penalties that can be sought are usually, unfortunately, the payment it goes to the Crown, but there are circumstances where you can ask for the payment to be paid to either party. So there is a path there, but it's not the ideal path. And it seems to, unfortunately, favor the employee a lot more than it does the employer. So always keep in mind that you need to be very clear and open, and you need to provide as much information as you can, well within your right to provide as well. You don't need to go unnecessarily above and beyond. Each process will be different, but you need to provide as much as you can so that you can back up your case. In terms of another thing to consider, being responsive and communicative. Again, broader terms, what does this actually mean? Well, if an employee has raised concerns, this is something that I have seen time and time again. If an employee raises concerns, then they need to make sure that they raise concerns within a timely manner and that they're not remaining silent. If an employee does raise their concerns in that timely manner and the employer is made aware, then the employer does need to act on this. It's also about your managers. It's about your HR team. If things have been raised and if something has been flagged, then it's really important that it's not being ignored or put to the bottom of the pile. And the reason why, it's not me, don't shoot the messenger. It is to do with the fact that you need to be responsive as an employer, and it's a good faith obligation. Now, in terms of the employee, this is where it gets interesting. So to be responsive and communicative, like I said, it's a two-way street. All of these good faith obligations, two-way street. And why it's a two-way street is that employees can't just sit on an issue. They can't just sit on the issue and hope for the best. They need to raise it with people. If there's a policy in place, like a bullying and harassment policy, there's usually going to be a pathway for how you need to raise these concerns and raise these issues. If the employee has not done that, if they have not followed policy and they've acknowledged it and signed it, if you have no policies and they haven't raised it in general, then how is an employer meant to know? And this is where, if an employee, let's say, just sat on it and they thought, hey, look, I'm waiting to raise a constructive dismissal claim. And a constructive dismissal claim, keep in mind as well, is where an employee can resign because they're saying that the circumstances at work were so bad that they had to tender in their resignation. If that is the case, then the employee cannot walk away saying, I have a successful personal grievance claim, because they haven't raised it. No one knows about it. But the catch here, and I would say to be careful, which a lot of people don't talk about, I've noticed this, is that yes, the obligation is on the employee to raise things in a timely manner and to express their concerns and make it very well known to the employer. But if people around the workplace, and I mean managers, people that are in HR, if they are seeing that there are issues maybe between two particular employees, then they need to step up. That is also a requirement from an employment perspective as well, is to be responsive. So it is really important that the employer doesn't just turn a blind eye to certain things. So if you have an employee that is being terminated, then another thing you really need to focus on here is making sure that they know as much information as possible on why you are making this decision. And they need to be able to provide their feedback. Now, you may be thinking, we always get their feedback, but you'd be very, very surprised on how many processes we see as employment lawyers where there hasn't been every box ticked, there hasn't been every T crossed and every I dotted. And it is really important with these ones, especially when you're looking at termination, that you've not only followed procedural fairness here and you followed the process from start to finish, that you also have the correct justifications. And justification is really important. And it's all about making sure that you've covered everything off, that you've provided. So in a disciplinary process, that invite to disciplinary meeting, you've presented all of the allegations very clearly. Then you need to make sure that you give them that time to provide their feedback. They need to have that opportunity. So that's why you do the invite to disciplinary. That's why we get their feedback. And that's why after their feedback, we're still proposing an outcome so that they can provide further feedback, because it's really important to keep the relationship constructive. And the last part I would say that's really important, which I've already mentioned, is good communication. And again, broad term, but make sure you check in with your employees. I cannot stress enough how important a catch-up can just be with your employees, even if it's every week, every fortnight, just to check in with them to see how they are going, because it doesn't leave any room for the employee to say that they were not given an opportunity to speak, that they didn't have any chances to present any issues about the workplace, because you are being active and proactive as an employer. So I know that this can sometimes seem like, oh, this is an extra step that I've got to do. I've got to run my business. I understand that. So however you can fit this in, whether it's a manager kind of stepping in and helping with these to not only upskill them into more leadership type roles, but also to help take things off of your plate, or whether it's that you sit down every fortnight, for example, with a handful of your employees if you're a really small business, and you just meet with them each individually just to find out what's going on. Even having a reminder that gets sent out saying, hey, if you've got anything to raise, we're just taking any questions, any of this information. There's just so many things under the sun that you can do. There is no hard or fast rule around this. Where the hard or fast rule does lie, though, is in your duty and obligation to act in good faith. And if that is the case, then you need to make sure that you follow this as an employer and as an employee. So that's it for me, everyone. I hope that this has been really useful. And before you click off, I just wanted to say thank you to everyone that's listening. Please make sure that you subscribe to the podcast and that you come over and connect with me on LinkedIn. I post there regularly. And like I mentioned earlier, the podcast is growing and I'm so excited to see where it's going next. If you want to secure your spot, then please subscribe. I've got the link down in the description. And if you're new to this, hi, my name is Sanam. Check out that link because that will have some information a little bit about me and what this is all about. Well, thank you so much, everyone. I hope you have a lovely day, night, evening, morning, whatever it may be. And guess what? I'll catch you in the next one, everyone.